Oyez, oyez, oyez. The Court of Appeals for the 4th Judicial Appellate District is now open pursuant to call.
Good morning, everyone. Welcome to the 4th Court of Appeals. The court welcomes the advocates on this Zoom virtual platform, as well as the interested parties and general public viewing these proceedings on the court's YouTube channel. Please be aware that should we suffer any unforeseen technical difficulties, I will stop the clock. If necessary, I may temporarily suspend the proceedings and the judges will recess briefly. Our Court of Clerk, Mr. Michael Cruz, will provide you with further instructions and assistance as needed. Once resolved, I will resume the hearing and counsel will proceed for the time that remains allotted to her or him. In light of the virtual nature of these proceedings, I wish to provide some guidance to help you navigate through the panel's questions this morning. The justices have decided to raise their hand like so when she wishes to ask a question. I may have to verbally and politely interrupt you should your attention veer away too long from the screen. At this time, beginning with counsel for appellants, I call for announcements in cause number 0420-051 CV, Medfinmanager, LLC versus John Salas. Counsel for the appellants.
Your Honor, this is Renee Yanta. I have the honor of representing Medfinmanager, LLC, which we call Medfin in this appeal.
Good morning.
Good morning, Madam Chief Justice. Carl Cobb here on behalf of the appellee and counter-appellant John Salas. I'm ready to proceed.
Very good. As you know, you each have 20 minutes to make your respective arguments, and appellant will have 10 minutes for rebuttal. Counsel for appellant, you may proceed.
Thank you very much, Chief Justice. So to Medfin, this was supposed to be one of the customary breach of contract cases, and that's because Mr. Salas, he was suffering from herniated and bulging discs, and his doctor prescribed for him to have spinal fusion surgery. The problem was Mr. Salas did not have the funds for that surgery. He did, however, have a personal injury case, and his attorney at that time, it was the Carlson Law Firm, and his doctor both reached out to Medfin and asked Medfin to consider including Mr. Salas in the Medfin program. This program enables personal injury plaintiffs on some occasions to be able to get their medical treatment immediately with the caretakers of their choice. So the doctor was told that this was not a workers' comp case, that Mr. Salas had not suffered an on-the-job injury. The Carlson Law Firm informed Medfin that this was not a workers' comp injury. And that's important because Medfin will not include in their program cases that involve workers' comp. So the way the program works is Medfin has created relationships and signed what's called master service agreement, which is a holistic factoring agreement between Medfin and various healthcare providers. The healthcare providers are required to establish the rate that they're going to charge for the services, although Medfin does set a ceiling. It says you can't charge more than your charge master rate. Medfin will then serve as the attorney in fact for the healthcare providers in order to make the program work. And then Medfin will guarantee that if the doctors choose to sell the accounts receivable that is created as a result of this treatment, that Medfin will in fact purchase those accounts receivable by assignment. And that is exactly how the program worked here. Medfin sent the program information to Mr. Salas's attorney at the Carlson Law Firm. It explained the program in writing. It provided the healthcare provider's estimate, and Mr. Salas signed that he acknowledged all of this. It also included a contract for payment, which Medfin had created on behalf of the doctors as the attorney of fact for the doctors. This contract for payment was signed by Mr. Salas, wherein he promised, I'm going to pay this bill, or these bills. Number two, I agree that and acknowledge that there is going to be a medical lien. I also acknowledge that there's a strong likelihood that these medical bills will be sold. And also, Mr. Salas, although he had actually filed a workers' comp claim in January 31st, 2014, unbeknownst to Medfin and unbeknownst to his doctor, Mr. Salas promised that he would not submit to either insurance or governmental programs, just these medical bills. Didn't bar him from making a workers' comp claim, but solely said he would not submit these medical bills to effectively workers' comp. Mr. Salas, represented by counsel, and having even spoken with his counsel, and this is undisputed, he had talked to his counsel and they had decided, they had talked about whether Mr. Salas should just proceed through workers' comp. Again, unbeknownst to Medfin and apparently the doctor. But Mr. Salas got advice from his counsel that just proceeding through workers' comp, heading into workers' comp, and relying on workers' comp would not be a certain result and would take considerable time. So what Mr. Salas did is he took himself out of the workers' comp system for this particular treatment, and he signed the contract for payment. And then he chose to show up for that surgery and in fact underwent the surgery. As a result, just as the program expects, all the healthcare providers created bills. Those bills resulted in accounts receivable. They each sold the accounts receivable to Medfin. Medfin provided those assignments to Mr. Salas's attorney exactly how the program was supposed to work. Medfin even delayed seeking payment on those bills, just as everyone expected, while Mr. Salas's personal injury case continued through the process. During that time, Mr. Salas, oh yes, ma'am. Yes, Your Honor.
Ms. Yanta, I have a question. Going back to what you just stated, you said each sold to the accounts receivable to Medfin. Can you please clarify that and be specific?
Yes. In fact, I would refer the court to Clerk's Record 742, which is an example of the sale and assignment of the medical bill. And it says here, please be informed that the undersigned, and this one was Dr. Linderman, has assigned to Medfinmanagers all rights, title, and interest for the above account. And that account was for $14,313, which was Dr. Linderman's services for provision of the spinal fusion surgery. So the described account now or hereinafter owing to it, upon which you have been obligated to pay as a third-party obligor. And it is signed by Dr. Lindemann, and that document, and for each one of these accounts receivable was provided to Mr. Salas through his attorney.
Okay, and is Dr. Linderman the only medical provider who executed that particular contract?
No, Your Honor. Every single one of these healthcare providers executed their own assignment, from Foundation Surgical Hospital through Dr. Gutzman, who was the primary surgeon and the captain of the healthcare team.
Okay, and are those particular contracts controlling, and are those the only contracts that are controlling here?
Well, there are a number of contracts in this story. There is also a master service agreement, which was an agreement between all these different healthcare providers and Medfinmanager, where they agreed, and as I discussed, that they agreed and created this program, where each one of these doctors agreed that they wouldn't charge more than the charge master, and they would set the rate. That Medfinmanager would be their attorney, in fact, for the program.
Okay, Ms. Yanta, I'm sorry to interrupt you. Just just to save time, you've already delineated what that master service agreement states according to your position.
Yes.
I want clarification from your perspective, which contracts are in play?
Right. The operative contract that is in play that we're seeking to recover from, there's basically two categories. One is called the contract for payment, and that is the document that Medfin created as attorney in fact for the doctors, where Mr. Salas signed with advice of counsel, signed saying he was going to pay these medical bills. He understood that and there's a contract for payment like that for every single one of the healthcare providers where Salas makes that promise.
Okay, and within those, let's assume, I believe there's 4 providers. Is that accurate?
That's correct.
Okay, so those 4 contracts that are applicable to those 4 medical providers, each one of those you're representing that Mr. Salas signed.
Yes.
And also each medical provider signed that contract as well with respect to each of their medical services?
No, Your Honor, it was a unilateral contract. It was this: I promise to pay if the doctors do the surgery.
Okay, so that's a unilateral contract. Set that aside.
Correct.
You said that there was one more contract or set of contracts in play.
And these are effectively an oral contract, and that is the accounts in our evidence by the accounts receivable. So just like all of us, when we go into a doctor and the doctor does some kind of procedure, we have an obligation to pay the doctor. That is evidenced through a medical bill and is an account receivable. An example of the medical bill can be found at the clerk's record 1195. And this is the bill for John Salas's provision of care, and it's from Dr. Gutzman. It's an example of one of the bills that became an accounts receivable that Medfin later purchased and then stepped into the shoes of the doctors to be able to directly seek payment from Mr. Salas.
Okay, and are you relying on extrinsic evidence to support that position?
If you mean, am I relying on Mr. Salas saying that he did in fact submit himself to the surgery and that he knew he was going to have to pay, there is evidence in the record of that if it would be required. I don't believe Mr. Salas disagrees that he in fact engaged in a relationship that created this. He doesn't disagree that he promised to pay us. I'm sorry, Chief Justice.
No, since we're on this point, so there, and Medfin also makes a distinction on appeal between the accounts receivable and the lien securing repayment. Below, Medfinmanager also, particularly in its summary judgment, for example, it relies on basically a contract between Medfin and Salas. On appeal, it appears that the argument is different in terms of your position on the breach of contract claim. But more specifically, you would agree that, well, as you've presented on appeal, that there is a distinction between the accounts receivable contracts and the contracts for payment, the medical lien.
And
yes, and the rights thereunder are distinct. Very good. But I wonder if below the Medfinmanager sought payment pursuant to the a contract between Medfin and Salas, which particularly were those contracts?
I would point the court to, again, the contracts for a payment, those documents which Medfin created as part of its program, and then Medfin stepped into the shoes of the doctors under the accounts receivable. And Your Honor, I do have to tell you, I came in that case toward the end, and we did make those arguments below.
Yes, very good. Well, specifically where below did you make? Because I'm a little concerned about whether the same arguments made on appeal were made before the trial court. Can you point to where in the record those similar arguments regarding while Medfin may validly hold the accounts receivable as an assignee, the argument that it has the security, which is provided under the contracts liens document, I wonder where was that presented below?
Well, I think that there is a transcript in the record of the trial to the bench on the breach of contract claim, where the whole issue was whether the Workers' Comp Act makes illegal the contracts for payment and bars Medfin, standing in the shoes of the doctors, from recovering under the accounts receivable. There's two separate theories. Those were not only presented by us, but they were actually argued against by Mr. Cobb. And that is why he relies on two different provisions of the labor code. He argues that 406.035 bars the contracts for payment. He argues 413.042 bars us from directly, yes.
So yes, setting aside for a moment the appellee's case as an affirmative defense to the breach of contract claim, but the claims made again that were the elements of your breach of contract case below, the one that trial court dismissed, that found as a matter of law that there was not a valid breach of contract claim from under which Medfinmanager may pursue. Again, there still remains for me a separate question as to whether the medical providers assigned their contract lien to Medfin. So while Medfin might be an assignee to the accounts receivable, the contract liens where a security is provided for this accounts receivable, how does that and how and where does Medfinmanager step in the shoes? Where's the evidence that the contract lien with the security was transferred, assigned, that Medfinmanager stands in the shoes of the medical providers in that regard?
Your Honor, I would refer the court to the exemplar, which is Clerk's Record 742. And in that, there's a notice of sale and assignment. And it says that, remember that the account is created pursuant to the contract for payment, where there is a...
I do understand that. I understand that this notice of, I can't see, the notice of sales and assignment. This is, and I don't know that it's disputed. This is evidence that the accounts receivable were transferred to Medfin.
Right.
But what evidence, as a matter of law, was there that the contract lien was assigned to that Medfin has as an assignee, the security interest, the lien that it seeks to pursue in attaching to the settlement proceeds? Because again, I don't believe it's disputed that the Medfinmanager is the assignee to the accounts receivable. But in terms of the security, where's the evidence for that?
I would argue this, Your Honor. First of all, even if we don't have a lien, we have a contract right to recover. So the lien, while is helpful to us because it gives us security, the lien itself is not what gives us the right to recover under the contract. So a lien is secondary to the promise. It's a second promise. It's a promise that says, I am going to secure my obligation to pay you with something else. So I don't think it's dispositive if in fact the court were to find that somehow the lien didn't transfer to Medfin. That's not dispositive because the contract for payment and the ARs did. And I would say this, because the language is very broad in the sale and assignment, And also, this is really important, the master service agreement specifically recognizes that part of this arrangement is that a medical lien will be established and the medical lien also gets transferred. That's agreed to in advance. So I'm happy to provide the court after this oral argument, the actual page of the master service agreement where the parties recognize that a medical lien is going to be established, and that is part of what is sold and assigned to Medfin. Yes, Your Honor.
And I perhaps misspoke earlier when I asked about extrinsic evidence. I meant parole evidence, so forgive me. And that's what I was trying to get at. So let's discuss the lien, Ms. Yanta, or not the lien, rather, you said the master service agreement.
Yes.
And you're saying that within that master service agreement, there are lien provisions. And who's bound by that master service agreement?
The doctors are bound and Medfin is bound. Medfin promises it will purchase these if the doctors choose to sell. And the doctors promise that they will, establish a rate that isn't higher than charge master, will allow Medfin to serve as attorney in fact. And if they sell, that they're going to sell every single right and interest they have from them to Medfin. So I think that that's the language you may want in order to assure yourself that the lien also transferred. And I'm happy to provide the clerk's record site for the court to that particular information. But what this ends up meaning is that there are two avenues of contractual promises, and that's really important. That is the central point here, is that there are two promises. One's to the contract for payment, and one's by submitting himself, Mr. Salas submitting himself to the court. And it is undisputed in this case that the spinal fusion surgery was not covered by workers' comp. It was not part of the treatment that was provided by workers' comp. It fell outside of comp. So the trial court erred by concluding that workers' comp provisions would in fact bar this promise because it's a promise for treatment of an injury that this record clearly shows falls outside of comp. And I'll reserve the rest of my time if the court does not mind.
Thank you.
Thank you, counsel.
Okay, please.
You may proceed, please. Thank you.
Thank you, Your Honor. Justices, this case is one that deals with an issue that's under discussion really throughout the country, not just in Texas, regarding the financing of medical. And no one on this side of the case contends that legitimate factoring of a pre-existing account receivable is problematic, whether in this case or any other case under the paid or incurred statute. But what we have here is a little different. First of all, the so-called factor, Medfin, attempts in advance of a procedure to manipulate the amount of the receivable while simultaneously having the doctors agree that they'll never charge more than a given amount. And in order for the Medfin program to work, what you'll see in the record is that Medfin, in writing, tells the medical providers how to misrepresent a number of things. And the medical providers agree in their depositions that some of the answers that Medfin asked them in writing to give to depositions on written questions are simply false. For example, the original amount of the bill, and that may be subject to some debate, but certainly what was already paid, any write-offs, who paid, what amount is still owed to the doctors, and I emphasize to the doctors, because at that point, nothing was owed to the doctors according to their own testimony, and yet their testimony is that this amount is owed to them. And even whether or not the doctors have been told how to answer questions, in the depositions on written questions, Medfin fills out the answers for the doctors, sends it to the doctors, tells them how to answer these questions, and yet in response to, I believe it's question number 8 in some of these depositions on written questions, the doctors falsely state that no one's told them how to answer the questions. It also requires the doctors to withhold documents that they admit are responsive to the subpoena. And that's what's required to make the Medfin scheme, unlike some other programs, which are real factoring, to work. And so then, of course, you can only imagine the harm that could come to a plaintiff, for example, if it were discovered that his doctor's answers to depositions on written questions were false. That is not fair to the plaintiff, and it's certainly not fair to the defendant, who's denied an opportunity to show what is actually incurred or paid or what's reasonable too. And there's the Primoris Energy case out of Houston, a fairly recent case, that in part addresses some of these issues but did not have, as this court has before it today, evidence of what the actual agreement of the doctors was. So, and then of course, there are the 2 provisions of the contract for payment that we contend violate 406.035, the waiver of workers' comp benefits, which I would point out is not limited, as Judge Yanta has indicated, to just this claim. It says he waives all benefits under workers' comp. And it does so with respect to a man that, and again, I'll disagree with Judge Yanta on this, did tell Medfin that he had filed a workers' comp claim. And in I believe both of our briefs, there's a screenshot of what Mr. Salas told Medfin. He said he hadn't had an accident before this injury, and he hadn't had one after, but he had filed a workers' comp claim. And so while the forms are a little squishy, to coin a phrase, but the clear meaning of that is I haven't filed any other claims other than this one, but I have filed a workers' comp claim. So, it's our position that Medfin clearly knew. Now, and I'll address, if I may, your questions, Chief Justice, and Justice Chapa's questions about what Medfin actually sued upon. Medfin actually sued upon the document called Contract for Payment / Medical Lien. And this is the document where the lien is allegedly created. We know that the doctors didn't know about it, didn't see it, didn't sign it, and don't consider themselves a party to it. So the promise was not made to the doctors by Salas to pay anything according to this contract for payment, which I'll just describe it as that. Medfin contends for the first time here on appeal that, well, we were the attorney in fact for Medfin, so we could just enter into that agreement on behalf of the providers with Salas, but that is not the case. And if the court will review the power of attorney that Medfin relies upon, it is in the what Judge Yanta has called the master service agreement. I've called it in my brief Medfin provider contract. The power of attorney does not allow Medfin to do anything until after these accounts have been assigned, and it's specific about what it allows Medfin to do. It allows.
Mr. Cook, I have a question. It doesn't allow them to step in until it's assigned. By whom?
Well, the plan works where 2 things have to happen. The account receivable is assigned to Medfin by the providers. That's one thing.
By the providers, okay.
Yes. And 2, the master services agreement, the Medfin provider contract, requires the doctors to provide what is referred to in that document as a, quote, lien letter. And that never occurred. The doctor did not ever assign that lien letter, which is the contract for payment / medical lien. That didn't happen. So there was no assignment by the doctors of the contract for payment, and they didn't even enter into it. They couldn't have assigned it because they didn't even know about it and didn't assent to it. On the other hand,
So essentially, if I may interrupt you there, so essentially the doctors, or the medical providers rather, are the only parties who are in a position to actually make those assignments, not Mr. Salas.
that's correct. That's
Thank you
correct.
for that clarification.
Yes, ma'am. So the power of attorney simply allows Medfin to do 4 things. It's very clear. 1, receive and endorse checks to the provider for payment. That is not the case here. 2, receive an open mail to the provider related to the account. That's not the case here. Notify the patient or his attorney of the assignment. And while that certainly doesn't allow them to enter into the contract itself for the doctors. And 4, collect the account in the doctor's name. So when Medfin at trial, they said, no, these contracts for payment are between the doctors and Mr. Salas. And our point was, well, then why didn't the doctor know about it? And so now for the first time on appeal, the argument is raised that, well, we actually had a power of attorney. That's why the doctors didn't know about it, because we did it for them. But without a power of attorney that empowers, yes, Your Honor.
On this point, I asked counsel for the appellant whether or not this theory was presented before the court, and she indicated that it was, and would point the court to that evidence in the record. You say now that it was not. So how do you respond to counsel's contention that it was addressed even indirectly in some way, as you understand her position? How would you respond?
Your Honor, at no time in the trial court proceedings was the power of attorney to enter into the contract for payment ever raised. To the very best of my recollection, I never heard that. I didn't see it in reviewing the trial court's record, and I certainly didn't address it in the brief for that reason, because it's the first time I ever saw it was in the appellant's brief. So there was, to my recollection, no time when the power of attorney to sign this contract for payment was ever raised.
May I ask a follow-up? And I'll ask the same to a counsel for appellant. But if, as Salas contends, that the contracts for lien, the contract for payment / medical lien, if that document is deemed invalid or unenforceable, as you lay out, could Medfinmanager nevertheless pursue its breach of contract claim based on the accounts receivables alone?
I think I understand your question, and the answer is that I suppose they could sue on an account, but they didn't. They didn't sue on a sworn account. They sued on the contract for payment.
And I know that was your response in your brief, that because they did not plead a suit on an account, that they could not collect on the claim. However, if we understand that a sworn account is not an independent cause of action, and it's really a procedural rule that isn't really necessary to establish a prima facie case, so it's not in and of itself a claim. And as Medfin asserts in its briefing, it sought payment not only for the contract for payment / medical liens, but also as an assignee under the assignments of the accounts receivable, which she points to. So could the breach of contract claim be pursued as an assignee under the accounts receivable alone, and not as an assignee or someone who has transferred the security interest, as it also claims in the alternative?
There's a couple of issues that come up there in my mind. And one is, first we got to decide, well, what is the account? Where was the account established, and what's owed to the doctors? And what amount is still owed to the doctors? So the medical services, or the master service agreement, as Judge Yonker refers to it, contract between Medfin and the providers, has some language in it which I've been accused of taking out of context, but it's pretty clear, and Mr. Joel Klapik, Medfin's principal, agrees, would have the effect of extinguishing the account. And he even testified that while he didn't believe that language was in the account, that the language, which I was reading to him from the agreement, is obtuse and would change the meaning of the agreement between Medfin and the doctors from being a factor agreement to being senseless. That it doesn't accomplish its purpose, because when Medfin pays the doctors this is an aggregate sum, the $69,000, that the doctors' bills are fully paid. And there were some terms of art in there. One was bill and one was an account. And Klapik testified that those were very different in the language used in the contract as bill. So we first of all contend that when under the agreements between Medfin and the providers, that it is unambiguous that when Medfin pays the provider, his bill is extinguished, and it is not shown to be the purchase of an account. So, and I'm sorry, I think I have lost my train of thought on part of the answer to your question. I apologize.
That's okay. You may proceed.
Okay. You know, there are a few things that I think are really important for me to point out to the court. And I'm not accusing any of the lawyers here of intentionally misrepresenting anything, but there are some statements that are flatly false, that are just wrong. And I want to address those. One, the TWC never made a finding that this surgery was not covered. That never happened. And I can go into detail on that. Two, I've mentioned the power of attorney that is now relied upon. It does not allow Medfin to enter into any contract on behalf of the doctor, other than as goes to receiving payment. And on the attorney's fees issues for both parties, Medfin denies that its attorney's fee experts and proof were stricken in the motion in limine, and they were. And they were stricken by Judge Posa in items 30 through 34 of our motion in limine that was heard, I believe it was the day before we began the second phase, if you will. And Judge Posa ruled that way because Mr. Poncio had not complied with an order to produce by, I think it was August 9th of 2019, expert materials for his attorney's fees. So Judge Posa was absolutely within her discretion to deny all attorney's fees under any theory to Medfin. Regarding our attorney's fees, our litigation costs under Rule 167, Medfin contends that we did not file the required declaration with the trial court, and she points to the docket sheet from the clerk's record. But if the court will look at our three last answers filed in this case beginning in January of 19, the declaration is in there in each and every one. And I can give you the clerk's record references, page 250, page 270, and page 1525. Each and every one of those contains an answer, or shows an answer filed by Salas, in which Salas declared the applicability of Chapter 42 of the Remedies Code and Rule 167. And so I thought it was really important that I point those items out, because it can save everybody a little time, perhaps. So regarding the illegality, if I can address that for a moment, Labor Code 406.035 is very clear, and it says an agreement, except as provided by the subtitle, an agreement by an employee to waive the employee's right to compensation is void. there's no question that this contract for payment includes that provision. And its harm to Salas is not hypothetical in this case. Salas was actually a workers' comp claimant. Salas had actually told Medfin that he was a workers' comp claimant for his one and only accident. So, Salas, as we know from the testimony in this case, particularly Mr. Josie, whose testimony, who's a workers' comp expert, one of the leading ones here in Texas, his testimony was offered by Medfin itself. And he testifies that Salas could have gotten a surgery, maybe not this fusion surgery, but a discectomy, a different surgery that met Office of Disability guidelines. And that Dr. Linderman could have performed that. Linderman testified that his practice is 60% workers' comp. He would have done the surgery and he would have taken his chances on whether he could convince Texas Mutual Insurance Company to pay for it. So the harm to Salas in terms of the waiver of workers' comp benefits is not at all hypothetical. When this contract for payment was allegedly entered, and again, we contend it never was entered. It was February of 14. It was before his surgery. It was before anybody knew whether or not he was going to be able to get a surgery paid for by comp. And as Medfin says, it doesn't finance medical costs if the claimant's in workers' comp, and that yet, maybe through mistake, it did so here. But, yes.
It appears that the Medfinmanager makes an argument that essentially goes to jurisdiction, and I'm going to ask her this, and I'll ask you now. But do you believe that her arguments about whether or not, again, her argument is twofold, really, that the compensation, quote unquote, the word compensation under the Act is not available, and for two reasons. One, because the automobile accident didn't cause the spinal condition. And second, that Salas had not exhausted his administrative remedies. So do you, how do you respond to this sort of jurisdictional argument she makes?
Well, first of all, TWC did not find that the surgery was not compensable. That never happened, and neither did the trial court. The trial court didn't need to make a determination about whether he was or wasn't entitled to the surgery in order to interpret the contract and decide whether it's enforceable. But moreover, the key from the cases that have been cited seems to be that if a claimant seeks to recover benefits that have been denied, recover in the district court the benefits that have been denied at the TWC, that's one thing. That would trespass on the jurisdiction of the TWC. But where he's not, as here, John Salas wasn't asking in this case with Medfin for any benefits that had been denied, much less any benefits at all. He was simply defending a contract case. And, I guess, I realize I just ran out of time, but if I could just throw out sort of a rhetorical question, if that were the case, then wouldn't Salas be bound by the finding of the TWC in his personal injury case? And why would anybody pursue a personal injury case to recover surgical expenses if they had been denied by the TWC, if this argument is correct? But it's done all the time. We know it's done all the time.
Very good. Thank you, Mr. Cobb.
Thank you.
And counsel for the appellant, you have your rebuttal time. And if you could follow up on that, just because your argument that it's jurisdictional, but how would you respond to the position taken essentially that this is not a question regarding an employee's entitlement to benefits under the Act, that instead and that the court's not deprived of subject matter jurisdiction over this matter? You're on mute, counsel.
Thank you, Your Honor. Thank you, Justice. Am I still muted? No. Okay. Thank you, Chief Justice. There is no question here that the central foundation of their claims in this lawsuit was that the injury that was treated by the spinal fusion surgery was covered under workers' comp, and that the provisions of workers' comp controlled the treatment and that injury. And Justice, the record here is absolutely clear that that's not true. And this is page 1200 of the clerk's record. TMIC denied compensability for herniated and bulging discs, which is exactly what the spinal fusion surgery was treating. There's no question in this case, the spinal surgery was not for a left shoulder. It wasn't for lower back strain. That would be crazy. Nobody goes and has spinal fusion surgery when you've got a strain in your lower back. No, what Dr. Gutzman did was he said, you have herniated and bulging discs, and that needs to be treated by spinal fusion surgery. And what TMIC ruled was that the herniated and bulging discs were caused by degenerative disc disease, which was not caused by the on-the-job injury. Now, why Lowe's didn't address that in the underlying case, I don't know. It's not before the court, frankly, and it's way beyond Medfin's role in the case.
Is it possible from the record to that it reflects more so that the trial court viewed the agreement as invalid, or because it in fact it was an agreement by an employee to waive an employee's right to compensation? Did it not do that? Did the contract not require that the employee waive its claim, any potential claim under the act?
This is the what I'm going to answer. That provision of the Workers' Comp Act doesn't apply if the injury is not part of workers' comp. I argue, and I argued this to the trial court as well, even if somehow an injury that is not an on-the-job injury somehow falls under the Workers' Comp Act and is somehow limited and controlled by the Workers' Comp Act, which makes no sense and absolutely is not the law. In this court, even this court under the Valari case holds differently than that. But
Can I ask a follow-up, if I may? If that provision is deemed unenforceable, is it severable? Is it an unconscionable, illegal provision of a contract that could be generally severed?
I think under these circumstances, the answer is yes. And why? Because first of all, it was not a waiver of all the workers' comp claim. All it was an agreement by Mr. Salas not to submit the medical bills relating to this surgery to workers' comp. And he had already done that, by the way. Well, he hadn't submitted the bills, but he did in fact submit a request twice for the spinal fusion surgery. And both times workers' comp said, wait a second, this is not an on-the-job injury and we're not paying for it. If you, so I think it is severable. I absolutely think it's severable.
Even after we review the entire contract, including Medfinmanager's business practices, its business model, that it would be a provision, a severable provision?
I think so. In light of the circumstances of this case, in the very fact that we have the TMIC go all the way through to a final decision by the division that lists exactly what injuries are being covered. And that I would refer the court to page 1386 of the clerk's record, where they say, all that's being covered here is cervical sprain strain, thoracic sprain strain, lumbar sprain strain, failed back syndrome, and a left shoulder sprain strain on August 5th, 2013. And even just a couple months before, Mr. Salas had tried to get some additional treatment for his back. And the TMIC told them, no, we're not going to give you that treatment, and says, as a courtesy notice, TMI is continuing to, let me read it specifically. TMI is disputing the following body parts conditions: depression, anxiety and sleep disorder, cervical disc pathology, lumbar HMP, thoracic, bulging disc, right shoulder cup tendinitis. And then you'll see on page 1386, every one of those conditions is not included in the final decision of the commission. So there's no question in this case that the issue that the spinal fusion surgery was treating an injury or a condition that was not an on-the-job injury. And so as a matter of law, that finding is controlling, and the trial court had no authority to allow Mr. Salas to collaterally attack it. Now, I do want to point out to the court a couple more things in regards to the issue about liens. I would point the court to the contract for payment. And on the contract for payment, the actual title of that document is Contract for Payment / Medical Lien. And when you read that, the beginning part of this document is pointing out that the medical provider or its assigns is the parties or the beneficiaries of this promise by Mr. Salas. And it points out within the document itself that this is referring to professional bills that will be submitted for services rendered to me. So the contract for payment / medical lien document is expressly saying that this is part of the account. This is part of the medical bill. The medical bill is the account, and the medical bill is attached, a lien is attaching to the medical bill. And then we have in the notice of sale, all rights that the doctors have are being transferred. It says here, all rights, title, and interest.
So which document has the security interest?
I think the notice of sale evidences that the security interest is being transferred. So this medical lien,
Right. But which document contains the security lien, the lien that is held by the medical provider?
The contract for payment / medical lien creates.
This is a document signed only by Mr. Salas,
Right.
that basically says
I promise to do these.
what it says, but I'm wondering, does it effectively create a security lien held by the medical provider? I mean, can a patient create a security interest held by a medical provider in this contract? I point to me the provision where the security lien interest is contained, because what I understand subsequently is that the appellant's argument is that the security lien is under the medical lien purchase and servicing agreement, which is where this appears to contemplate that the medical providers create the lien. So the security interest in the lien is in this lien document, is it not?
No, the lien is actually in what exemplar 1180. And there's a paragraph that says, I fully understand that I am directly, personally, and fully responsible to make payment in full to said provider for all professional bills submitted by it for services rendered to me. And the above stated is made solely for providers. The above stated, that is the lien, is solely for said providers additional protection and in consideration of its waiting payment. I further acknowledge that such payment is not contingent on any settlement, judgment, or verdict, which I may eventually cover as said fee. In the paragraph before that, I irrevocably authorize and direct any payer, including the defendant and or his insurance company making this payment of such sums, make the payments directly and fully to said provider. That creates the medical lien. And
In favor of who?
in favor of the provider. Okay, so it is the paragraph, it's paragraph 1, 2, 3, 4. Paragraph 4 of the contract for payment / medical lien.
And so are you saying that there is no, that medical lien is not contained in this document?
Correct. That document, the master service agreement creates, I mean, it could be belts and suspenders. I don't disagree with that. I mean, it certainly recognizes that this is what the procedure is going to be. The way this program is going to work is the doctors will set the rate. The doctors will provide the surgery. The doctors will create a bill. The doctors will get a medical lien. And then the doctors will, if they so desire, Medfin will buy that medical bill with the medical lien attached to it.
Very
And
good. You're welcome to close because I see that your time has expired.
Well, I really appreciate all the time that y'all have given us. Now, let us really make sure it's clear here. We have two bases for recovery: the contract for payment and as the assignee of the accounts receivable, just like any other factoring agreement. So regardless of the lien, we still have two contractual bases. Neither one of these bases is barred by the Workers' Comp Act. Why? Because this particular condition did not, as a matter of law, fall within the provisions of the Workers' Comp Act. And I thank you all so very much. We would ask this court respectfully to reverse and render this judgment. And if needed, remand the case to the trial court for entry of a judgment for breach of contract and attorney's fees for Medfin. Thank you very much.
No further questions from the panel? Very good. I will again invite counsel for the appellant to follow a letter, a short letter, brief to supplement your argument, your response to my question about where in the trial court record was there the argument, the assertion of the contract for payment theory of recovery, and any response by the appellee within 5 days after her filing.
Thank you, Your Honor. I appreciate that opportunity.
With that, your case is submitted and an opinion will be following shortwith.
Wish you all the best.
Counsel's dismissed and this case is now submitted. You may be excused.
Thank you, Judge.
Thank you,